Welcome back, friends. So let's get the formalities out of the way. I am not an attorney. I am not giving any legal advice, nor am I putting forth any legal conclusions. All comments are my opinion. All persons are innocent until proven guilty in a court of law. And oh yes, down below is if you want to join the membership for my channel, the link is in the comments. Also, so is the link if you want to help support Luna's BarkBox habit. And I know I've been talking about this for a minute, but I do have merch coming soon. I've been working on the designs, so that should be out within the next couple of weeks. So with that, oh yeah, I would, if you could please like, share, subscribe, comment on my videos, because the nature of these videos, a lot of times they are demonetized, so spreading that will help support me so I can continue making these videos. With that, we are actually in front of Judge Washington today. It's a couple of cases in front of her court, and I just thought they were kind of interesting. So let's go check into her courtroom and see what's going on.
State of Michigan versus Warrant Threats, case number 21S00413.
Kyle Bedell for the people.
Andrew Bannis on behalf of the defendant. Sir, could you state your name?
Warner Lee Threats Jr.
Thank you, sir. Good morning.
Good morning.
We're here today on a violation of probation.
Yes, Your Honor. And I'm sorry, I'm trying to recall, is this the actual sentencing or the pre-sentencing hearing?
I think this is the hearing before. I don't have that he pled to the charge.
Okay.
It may have been one of those days.
That's what I thought also.
So he was supposed to, no, he didn't plead yet. He was supposed to test within 24 hours of the last time I was here, but didn't report. Oh no, he was supposed to test within 24 hours of the time that he was before the magistrate and didn't do that.
So what I believe my client wants to do is admit to the allegations of not complying with probation without a hearing. And then after that, he and I would like an opportunity, if we may, to explain what's going on. And I just say it that way. So just to remind Mr. Threats that it's a two-part process. First would be the admission of not completing what he was supposed to complete. Then we'd have an opportunity to explain. Thank you.
Mr. Threats, the allegations in this particular case, you have the right to have a hearing on. It's my understanding that you're going to waive your right to have that hearing. Is that correct?
Yes, ma'am.
All right. So the allegations are you failed to report to probation. Oh, please raise your right hand to be sworn. Do you swear or affirm the testimony about the provide be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, my lawyer here. The allegations are that you failed to report to probation for over 5 months. Is that true?
Yes, ma'am.
You failed to complete the MAD victim impact panel. Is that true?
Yes, ma'am.
You failed to complete the CCOP program. Is that true?
Yes, ma'am. Yes.
And then you failed to drug and alcohol screen as ordered.
Yes, ma'am.
All right, thank you. I find that there's been a knowing and willing waiver of his right to have a hearing and that he has admitted to the violations. Are you satisfied, Mr. Bedell?
Yes, Judge.
Defense is satisfied. Thank you.
Thank you.
Your Honor, this is not meant to be an excuse, but I think my client's a bit overwhelmed. He's not that these conditions are too onerous. That's not what I'm saying. But I believe he's on probation in 3 different courts, including this one. I know he is working full time and he's a single father of 2 teenagers. I'm informed he faxed the release of information over to your court and maybe with some additional paperwork regarding his current treatment program. And I think just juggling the various probations has been challenging, but he's doing his best on the other ones. And obviously he needs to somehow get this one on track. And then I would just ask him to add anything in addition he'd like to say about that.
Before we do that, and before I don't know that I'm gonna sentence him today. It depends on some things that I'm gonna inquire about here. What is he doing on those other probations?
Well, I think I know, but I probably don't have all the details. So, Mr. Threats, can you answer the judge's question, please?
Yes, I can. Hi, Your Honor. It's just been miscommunication. Maybe it's my fault though. Oh, okay.
Hold on, Warner. Just first, what are you doing on the other probations?
Oh,
Just
one of my
treatment.
they're all my probations are I have to attend IOP. I have 3 remaining left for that. I've been in that for 3 months. I see my psychologist regularly. I'm working 70 hours a week. I'm taking my mental health medications. All the other courses I'm doing fine in. It was just miscommunication. Everything. I mean, I will admit it's my fault. After I got out of rehab, I've just had a lot on my plate, like a lot.
So it appears you are in intensive outpatient.
Yes, ma'am.
All right.
That's through Clinton Counseling in Clinton Township, Michigan.
Are you testing on any of your other probations?
I have a scram tether on. Your Honor, yesterday marks 90 days of sobriety. My first time ever in 20 years.
Congratulations.
Yeah.
Thank you. And
No joke. 90 days is a while.
so a week ago, I got a false positive on a scram. I was put on scram. My judge in Royal Oak passed away about 4 weeks ago. And I didn't know I had a court date because I had so many other things that were going on. So I went to court. He put me on scram. I got a false positive, but I violated before I went to rehab. So he sentenced me to 7 days in jail. I have to report to Oakland County Jail on the 2nd of January. And I have to do a 7-day jail sentence. I've been doing fine. I've been testing regularly. I haven't had a drink. My PO called me yesterday from Royal Oak and said it was a false positive. She said, I'm sorry I couldn't help you get out of this jail situation. I said, you know what? Accountability and responsibility. I made my bed. I have to lay in it, even if it was from August. You know, it's just, like I said, it's just been a lot. And I've been hearing you say progress. I've made a lot of progress. And I wish the judge would have seen that in Royal Oak, but like I said, since the judge passed away, he's just trying to be a little, tough on people right now, which is fine with me. I'm gonna miss a week of work. I'm gonna have to find somewhere for my kids to go, but I only see better from here on out. Like, this has put a damper on my holidays, but at least he didn't make me turn myself in before Christmas. He gave me until January 2nd to get my affairs in order. It's only a week. I'm just going to consider it a small vacation. I don't want to go to jail. I haven't been to jail in a long time. But when he told me to go to jail, I could almost taste the liquor in my mouth. But I'm not doing it for them anymore. I'm doing it for me. And this has nothing to do with the court, but as a parent, and to find out yesterday that my 14-year-old is smoking marijuana, it's really hurting me right now. And from, like I explained to her last night, it might not right now, but in the long run, you don't want to be 38 like your father in the court system going through this. I'm just at a loss for words. And I apologize to the courts. I apologize to Mr. Heaton. I've spoken to him a couple of times to let him know the situation. Like, when I got out of rehab, if I knew I was supposed to report to him, I would have been reporting, because I go to a place called ADAPT. I did an ETG. I do ETG tests. When I get out on the 9th, I have to go on the sober link, which I'm fine with. It's just, I'm gonna have to spend money. But the desire to drink is gone. But of course, I don't hang around people that drink, because like they say, if you keep going to a barbershop, eventually you're gonna get your hair cut. So I go to work, I take care of my kids, I go to IOP, I go to my appointments. And now I have a calendar, so I don't miss things anymore, And that was just like the biggest hurdle. I just had so many things, because when I violated one probation, it violated everything. So I've just been going from court to court, just explaining, once I got out of rehab, it's just been a juggling act, being a parent, being a provider, and in recovery at the same time is a lot for one person. And I've never been this, it's adulting now. Now I'm being adult, because I'm doing everything the right way. I'm doing everything opposite of what I used to. So I mean, Mr. Heaton wants to give me 10 days in jail, but like I told my lawyer, if that's what it is, that's what it is. There's nothing I can do but just show the court.
That's not the recommendation anymore.
Okay, but like I'm trying. I really am.
All right. Thank you, sir.
Yes, ma'am.
Anything from you, Mr. Riddell?
No, Judge. Other than I can tell Mr. Threats is paying attention in his programs. That expression about hang around a barbershop, you'll eventually get a haircut.
Yes.
That shows me he's paying attention, because I know that's a common phrase in the recovery community. So it does sound like he's making good steps. Ultimately, as to what we're here for today as the violation, I'll leave it to the court's discretion. But it's pretty clear Mr. Threats is taking this sobriety very seriously.
Thank you. Mr. Heaton, I see you unmuted. Is there anything you wanted to add, sir?
Yeah, I wanted to let you know, Your Honor, when I sent the report to Mr. Battis and Mr. Riddell the other day, I resent the report from November. I just wanted to make sure they were both aware that there's a new recommendation, in light of everything that Mr. Threats is doing. There's a new recommendation just for 2 days community service to reinstate probation for 10 months and to complete the IOP that he's in right now. We did receive confirmation from Clinton Counseling that he's doing the IOP program and doing well there.
Thank you. All right. Mr. Threats, I'm going to go ahead and sentence you at this time. I see that you're making great strides. You are, human. You're making some mistakes along the way, but you're trying and you're putting in the work. For that reason, I'm going to follow the recommendations of a couple of modifications, or one modification. I'm going to reinstate and extend your probation for 9 months. I'm sorry, 10 months. I am going to have you do 2 days of Washington County Jail, but you can do that in Clinton. You're going there anyway. Okay.
In Oakland County Jail. Yes, ma'am.
Oakland. Okay.
And Your Honor, I have no problem reporting. Like with Mr. Heaton, if I have to report every week, I report every week. I don't have a problem with it.
Thank you. Comply with the original conditions of your probation. You need to reach out to Mr. Heaton and you two can go over what he wants that to look like. Okay.
Yes, ma'am.
And so we're going to waive the CCOP class because you're in the IOP.
Okay.
Okay.
Yeah, I'm just waiting for my anger management class to open up and my COG skills class to open up. Clinton Council is just like overwhelmed, but I like going there. Plus I get my one-on-one. So it's just like I'm getting a lot out of the program. And also I just got a job making $26 an hour. Everything, like, it's been so much positive going on. Like, I just can't, it's like overwhelming. Like the positivity I've been getting, like from friends, family, work, my new owner, he's like, look, go do the 7 days, come home, your job is here. Like, I'm happy right now. I haven't been happy in a long time.
Good for you, Mr. Threats.
Thank you.
All right. Anything else from anybody else on this? Nope. Contact Mr. Heaton this afternoon, okay?
I will. Thank you, Your Honor. Happy holidays.
Same to you.
All right.
What will we call the cases of the state of Michigan versus Ernesto Zuniga Alvarez? Case numbers 22S000888, as well as 22W004900 A and B.
Kyle Burdell for the people.
Andrew Banis with an on behalf of Mr. Zuniga Alvarez. Ernesto, could you state your name again, please?
Ernesto Zuniga Alvarez.
Thank you. Your Honor, something that goes along with this job is a difficult decision of whether to move for a competency exam. That's a thoughtful process. There are collateral consequences. I always hesitate to do that in a misdemeanor unless I feel it's absolutely necessary and appropriate. Having said that, I'm asking for an adjournment to the next possible date so I can meet with my client again. I may need to file such a motion. And it's not just because I don't think he's following my advice about peacemaking court. I have other concerns about his understanding and his reasoning process.
All right. With that in mind, none of the bond conditions are gonna change.
I agree to that.
Pretrial, due- yes,
I need a splint because my pinky knuckle is broken.
all right. Thank you, sir. Mr. Banis, I don't know whether you need, well, I'll let you make that decision about whether you should be adjourning it for a competency based on what he just said. I have my own concerns about his competency. January 5th, 2023 at 9 a.m. The bond will continue and vote in all these matters.
Thank you. If just so you know, Your Honor, I don't think you're setting a deadline for me, but if I do file a motion, it will be before the end of next week.
Thank you.
Thank you, Mr. Banis.
All right, sir, I'll see you on January 5th, okay?
What is the A and W, if you don't mind me asking?
I'm sorry, what?
A and W,
A and W?
yes.
I'm not certain what you're referring to, sir. I'll see you on January 5th, sir. The court will call the case of the state of Michigan versus Marissa Ians, case number 22 FB 1155.
Kyle Riddell for the people.
Andrew Banis, Assistant Public Defender, with and on behalf of Ms. Ians. Ms. Ians, could you state your name, please?
Marissa Ians. Thank you.
Your Honor, we're here for sentencing. I reviewed the pre-sentence report and recommendation with Ms. Ians yesterday. I have no requested changes to the report itself. The narrative section is basically well, I should say includes comments from the probation officer. I do respect the probation officer's experience and insights, both probation officers in this court. I just respectfully disagree that the Ms. Ian should be sentenced to 180 days. She has no issues with any of the recommendations in terms of probation conditions. On her behalf, I would like to say a few things. First, she sent to me yesterday a document which I forwarded to Mr. Heaton and Mr. Burdell this morning. I don't know if that was printed for you, but it's titled a therapy enrollment report, and it's actually dated just 2 days ago. And I read it as very positive. Her initial assessment was in September. She attended all therapy sessions from mid-September to mid-December. The recommendation is continue therapy. It states she's on a path towards recovery. It says something to the effect of it would be beneficial for her to continue treatment in conjunction with court-ordered services and or monitoring. She is in treatment now. The letters of support, I know there's disagreement, but I think they should be given at least some weight. Even if all those people who have very positive things to say about my client don't know all the facts of this case, I read them as based on their personal experience knowing my client. So I think they should be given some weight. She told me she moved to Westland to change her environment. That's a good thing. She has a full-time job. And also, Ms. Ians, if I misstate anything, make sure you correct me. But she's a full-time job as a clinical therapist. She's a licensed social worker. She has 2 young children, ages 10 and 2. And as I said before, she's in counseling. So I ask that you follow the recommendation. And of course, with the suspended sentence, even if you grant my request to sentence her to probation without the 6 months in jail, she understands that's still hanging over her head. She needs to comply with probation, and I believe she will continue on the path that she is currently on. Thank you.
Thank you. Mr. Riddell?
So Judge, this is a very troubling case. Given the facts, the incredibly high blood alcohol content on it alone, excuse me, the incredibly high alcohol content in her blood alone is troubling, let alone the fact that there's an infant in the car and another in the rollover accident. And so, Judge, I would ask, and the defendant has also had some difficulty in complying with bond as we've been going on. So, Your Honor, I would ask that the court follow the recommendation from probation with potential to early release to treatment upon a bed becoming available.
All right, ma'am, we've been here before. The only thing I'm gonna say is that this is an adjourned sentencing. We went through this the last time you were here with you trying to persuade me that you were deserving of an opportunity to not have to do 180 days in Washington County Jail. And what would you like to say at this time then?
I just wanted to add to that I did receive the blood results back from the alcohol test that I completed for the October violation, and it did come back negative. I did send that to the attorney last night as well. Same still stands. I'm still doing pretty well with the substance abuse counseling, as well as my own therapist for personal issues and not just focus on substances as to why I use alcohol. And then also my doctor prescribed naltrexone, which is to curb alcoholic cravings, but I haven't had any. Still complying on the scram tether. I see Mr. Wells at Community Corrections every 2 weeks to download, no hiccups there. Just asking the court to grant me the probation terms. I will comply. I know he added the MRT program as well, that's fine. I just need to be there for my kids and my clients.
This case, as the prosecutor has said, is extremely troubling. You had a rollover accident where you were extremely drunk with your child in the car. I have reviewed all the letters from your family members and support systems. I have reviewed the letter regarding the therapy enrollment and how you're doing there, and I'm glad to see that. I also got this report that you sent to your attorney, who sent it to me from LabCorp. That report apparently tests for a chemical that's in the body that is produced if there's chronic alcohol use. That's not a test for whether or not you're actually, it's not an ETG test. They test two different things.
Can I comment on that? I think for the ETG, it was past the date, the time frame. So I took that one because it went a couple months back to just do the October.
I don't know how that works.
Well, yeah, I was just trying to think.
So, having said all that, I can't figure out, which is, I think, what I told you when you were here before, whether you are who you present as here in this courtroom, or that individual that got into the car accident. Can't figure out why you would violate your bond all these times, knowing that you were reduced from felony, which is very serious, down to this. If it's the addiction, if it's a combination of addiction and relationships, I can't figure any of that out still. But on so many levels, you bring me concerns about safety for this community. So I understand you have children, and I'm going to try to fashion something that takes all of that into consideration. Now, it is the sentence of this court that you served 365 days in the Washington County Jail. Credit for 12 days that you served. $323 days are suspended That leaves you serving 30 days in the Washington County Jail. I'll let you begin that sentence on January the 3rd. Fines and court costs in this particular case for a total of $525. You are going to be on probation for 24 months because I need to know whether you are getting it together or you're not. $30 per month of probation oversight fees. You to continue your treatment at the Black Family Development and follow our recommendations. You to complete the Community Corrections Moral Recognition Therapy program. You to attend the Mad Victim Impact Panel. Meet with probation when and where directed, including any and all home visits. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, and no being in the presence of anyone using those. No use or possession of any firearm components, ammunition, or other dangerous weapons. You must drug and alcohol test 2 times per month and continue, drug test 2 times per month and continue on the sober link. How old are your children?
10 and 2.
When do they go back to school?
January 9th, and daycare is still running throughout break.
So you have,
I have a question.
yes, ma'am.
Because I heard 365, my heart went up and down, so I kind of left. You said the 30 days on the 3rd. Is it possible if I could report if I can complete that on a weekend basis so I can maintain the structure for them?
I don't think the jail is doing that,
Okay.
but if they are, I will allow you to do it, but I don't think they are. I think they will only, I think it's a minimum of what, 5 days at a time?
I thought it was the whole sentence. They had to do whatever their full sentence was.
I'm sorry,
I said I thought it was they had to do whatever their full sentence was.
but they will, oh, is that how it works? Okay, so the jail won't allow weekends and all of that. You have to do the entirety of the sentence, or that's it at this time. They're not breaking it down into bits and pieces.
Would you like me to go make a phone call to verify that, Your Honor?
Yes, please.
Thank you.
I just emailed Arnett.
All right, thank you. I will allow whatever they will allow me to allow you to do.
I appreciate that.
Any other questions about your sentence? You need to contact Mr. Heaton, who's here. I don't know if he's gonna talk to you now, or do you want to call back later?
We can call back later so that I can get a hold of it, make sure everything is.
Okay, so you can contact Mr. Heaton later this afternoon by phone to sign your contract, to go over everything, but don't leave until we hear back from Ms. Johnson as to how the jail will accept that. All right, the court will call the case of the state of Michigan versus Aaron Brown. Case numbers 14W003896.
Yankee, number 86495, appearing on behalf of Mr. Brown today.
Thank you. And there's also the, all right, and 14W003896 as well as 078245542.
Kyle Burdell for the state.
Thank you. We're here on a bench warrant today. Did you ask for permission?
I have my P number, Your Honor.
Okay, yes, thank you. Congratulations. All right.
Oh,
So on these matters, you're here for a bench warrant for failure to appear back on December, well, the 9th of 2014 and the 2014 case, and then October 28th of 2014. One is open intox. Looks like both of them maybe, they're just worded differently based on the age of the particulars. Okay, this one is a minor in possession. The 2007 case, is that what that is? Yes, the MIP.
Here it is. I know.
Can't hear me?
Yes,
You
I
are
can.
pretty low.
You said what?
It is a little hard to hear you than it was earlier. I'm not sure why.
Okay, she's talking to me?
Yes, Mr. Brown, I was.
Okay, I'm listening. What'd you say?
So you're here from basically 2014 failure to appears.
Yes, I know about one.
Mr. Brown, I'm going to advise you not to speak right now about those. So, Your Honor, we did discuss that. They are just from one of them. It looks like he was not even arraigned on the 2014 one. It looks like, at least from when I checked earlier. And from the 2007 one, he didn't know anything about that one when we tried to discuss it. So we did have a discussion, and we would like to get these back on track. He is a role model for 4 children, and he does not want to put out that image for them. He would like to get everything back on track.
So in the 2014 case, so you're here for open intox in a motor vehicle. That is a misdemeanor. And it carries a maximum penalty of 90 days and or $100 fine and 2 points on your record. And then the other charge, you were already arraigned on that before for the minor in possession. That's from an event on May 19th of 2007. So you're saying you want to get these back on track for your client. We have the prosecutor here today, or do we? We have the prosecutor here, one of them. And the other one we do not. So what are you requesting at this time, Michelle?
Your Honor, I would like to request a personal bond, please. Again, we had a discussion we had an opportunity to speak this morning. He informed me he was not on probation or parole. He is being seen for one other case this afternoon with Magistrate Fink for an OWI. He does have a couple holds for him. There is one in Detroit one is for trespassing and 3 are for driving offenses. There is one in Shelby for a traffic offense and one in Warren for an open intoxication. We discuss how whenever he gets out of there, how he needs to take care of them and how to take care of them. Additionally, he is gainfully employed. He does have a family that he would like to get back home to for the holidays. Regarding possible bond conditions, he does not have a medical marijuana card and does not need to travel out of state anytime soon. He provided me, which I provided to the court, a good phone number, email, and address to be released to. We're going to ask for a personal bond again today, please.
Mr. Brunel?
So Judge, I have to apologize. I'm a bit flat-footed on this case. This wasn't on my docket sheet. I apologize. So I know he's got 2 cases. Which are the charges on the state case?
Charge on the state case is MIP.
Is that the civil infraction version or the misdemeanor version?
It is the misdemeanor version.
So it's very clear that, Mr. Brown has an addiction disorder here, given the charges in this county, in addition to the out-county cases. Given the nature of the charges and the age of the case, I have no objection to a PR bond. However, I would like to ask for a scram or a sober link tether. I think is appropriate, or at least regular testing.
No objection, Your Honor.
Well, I understand the concern for testing. I have more concerns for the fact that he's been gone since 2014.
Yes, Your Honor. That's why we have gotten good contact information, so this will not happen again.
Can I say something?
I wish that I believe having good contact information is what allowed people or required people to come to court, but that's not how this works.
Can I say something?
It's up to your attorney, sir.
I'd advise you not to.
Okay.
Really want to, but I advise you not to right now.
Okay.
All right. And in these particular matters, I'm going to give him a PR bond with tether, GPS. All right. Since we're here today, I don't know if the parties want to talk about trying to get at least the state matter addressed. And potentially, how long has he been in custody? Was it since last night?
Yes, Your Honor, he was picked up from Detroit on another matter.
He was he's in regular clothes, so okay. PR bond with tether. I'll bring him back here on January the 19th.
19.
At 9 a.m. No, we need to put these on a Township Day. All right, make that January 17th.
Okay.
At 9 a.m. Sir, if you're out, you also must test 2 times per month, okay?
Yes, ma'am.
You on what day, sir?
I can't hear you.
What day will you see me on?
17th, right?
That's correct.
I'll see you for sure. I don't have time to miss this. I'm 35 years old. I can't keep coming here.
See you on January 17th, sir.
Yes, ma'am.
Thank you.
Thank you.
All right, the court will call the case of the state of Michigan versus Amicus Conway, case number 23S00003.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Conway.
Good morning, Ms. Brandy. Sir, could you please state your name?
Amicus Conway.
Thank you. I know it sounds weird, but
No,
we
you're
hadn't
fine.
called the case yet, so that's why we have to have you state it once the case is actually called.
Understandable.
All right, we're here today for an arraignment on a new charge. It's my understanding the defendant is charged with domestic. Do you waive formal reading or do you need me to read the complaint, Ms. Perini?
Yes, Your Honor. Oh, we will wait for a reading and stay mute to the charges.
All right. Thank you. Having waived formal reading and standing mute to the charges, I have to inform you, sir, of the maximum penalties in this case. In this particular case, is for domestic on the date of January 2nd, 2023. It is a misdemeanor carrying a maximum of 93 days and or $500 fine plus court costs. Do you understand the penalty, sir?
Yes, ma'am.
All right, having said that, has your client signed an advice of rights?
I don't believe he signed one when we spoke this morning.
I just
That's why I'm
got
not.
that signing it.
You just finished signing it, sir?
Yes, ma'am.
All right, thank you. I am signing the request for appointment of attorney and I'm appointing the PD's office to this case. Well, I'm referring it to the appointing authority to appoint the PD's office. Sir, with respect to your rights, I do have to go over the basic parts of those rights. I'm glad that you did have an opportunity to sign it. You have a right to have a trial by a jury in this case, at which time you can call witnesses to speak for you, and you get an order signed by me to require that they come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, and you can choose to remain silent. If you do choose to remain silent, the prosecutor cannot comment on that. In addition to that, sir, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, ma'am.
All right. Understanding those rights with respect to bond.
Yes, Your Honor, we are asking for a personal bond in this case. I did review the prosecutor's bond form with Mr. Conway, and he does understand any and all bond conditions that the court may impose. I will have the court know that, however, that the complainant in this matter and Mr. Conway do live in the same apartment building. They do live in different apartments, but I believe it is the same address. So I did want to make sure that the court was aware of that. Additionally, the complainant in this case is the mother of his child. He does have one daughter. He is not working right now, but was in communication with Michigan Works to begin a new job. And he does have an MDOC hold. He says that it was a tether issue and that it was resolved, but I'm not sure if that is going to keep him in custody or not.
In addition to that, the allegations in this case seem pretty serious. The allegations indicate that he was pulling the victim into the apartment against her will, holding through her throat.
What? I never did that.
You weren't holding, well, maybe, okay.
No.
There's no to the throat. Well, you were holding at the time.
This first and foremost, the lady
You're
that
not
Mr.
talking about
Conway,
the facts of the case, sir. I'm not inclined to do a personal recognizance bond at this time on this case, based on the allegations. I need some input from the prosecutor's office. Other than what I have right here, the input from this one indicates that they're requesting a $10,000 cash or surety bond. That's what I'm gonna set the bond at this point. And we'll give him a earlier court date, January the 9th. My main concern is they live in the same apartment building. There's no way to manage this. I'll set it for January 9th, 2023. And that's gonna be at 9 AM, sir, in front of me.
Yes, ma'am.
That boy is just a walk away Joe.
I should say, I know he has left the space, but if he is released, then he has to have the standard testing conditions. He will report to community corrections within 48 hours for intermediate supervision. All the standard bond conditions of a also apply.
Thank you, Your Honor.
There is a no-go to that particular address. I understand they live in the same building, but if he's released, then he cannot go there until we can figure out something else. And he's to have no contact. Good morning, sir. What's your name?
Darius Ross.
Thank you.
Is it Mr. Ross?
Darius
Yes.
Ross. I thought he was, didn't you see me earlier today?
I just seen you this morning. Yeah, and we adjourned it out to the 31st.
Yeah, I think they have you at the wrong place. You can let them know you've already been seen this morning.
Appreciate
Okay.
you guys.
Thank you.
Thank you.
Good morning, sir. Could you tell me your name?
Yes, good morning, ma'am. My name is Pat Robert Thomas.
Thank you, sir. All right, Mr. Thomas, you're here to be arraigned on a bench warrant. You failed to appear in court on December the 8th of 2022 before me. We got a bond violation report on September the 9th, indicating at that time you'd been released to another facility in Wayne County, but VineLink showed that you were actually out of custody with them. You were on unsupervised custody out of the Wayne County tether unit, and yet you still failed to show for court on December the 8th. Ms. Carini, I am in receipt of a request for court-appointed attorney and a referral. I'm signing that referral at this time.
Thank you, Your Honor. And just to put my appearance on the record, Assistant Public Defender Lauren Perny on behalf of Mr. Thomas.
Thank you. With respect to the warrants.
Yes, I did speak with Mr. Thomas about the warrant. He indicated to me that he was not aware of the show cause hearing, and that is why he was not able to attend. We are asking for a lower amount of bond. At this time, he is not working. He is staying with his mother. He indicated that he has no money to pay any kind of bond. I believe it's set at $500 right now. Is that correct?
5,000, 10%, but he's not aware of that particular hearing potentially. Well, first of all, notice was sent to his last known address, but even before then, he failed to show up for a final settlement conference that he set. We set it over for a final settlement conference on November the 3rd, and he failed to appear for that. So he was aware of that court date, and then he missed the next court date too. So I gave him a second opportunity to show.
Yes, I understand, Your Honor. He just indicated he didn't know of that date. I'm not sure if there's any other explanation at this time.
Sir, you
Yes.
asked for a final settlement conference and I gave you that. You showed before me and requested it and I gave it to you. And then you didn't show up for that.
What was that? I'm sorry, ma'am. I missed that. I'm sorry. You said what now? I what?
You asked for a final settlement conference. You wanted a trial in a final settlement conference. I gave you a final settlement conference date on November the 3rd, and you failed to show. We set that on August the 29th when you were before me. I'm sorry, September the 19th. You showed for 2 court dates, August 29th and then September 19th. On September 19th, you said you wanted a trial. We set it for a final settlement conference and a trial date, and you failed to show at the final settlement conference.
Ma'am, I think I contacted my lawyer, the person that was representing me.
To say what? Because you had to be here in court. Are you still on International Drive?
Yes, that's my mailing address, yes.
We sent notice to that address, sir.
Never received anything, ma'am.
And you also don't remember me telling you to be here when you requested that date.
And I requested a date too. Like I'm a little,
What's confusing about you asking for a trial and getting a court date?
I'm a little discombobulated. I'm sorry, ma'am.
Do you have any sheets of yeah. Thank you. No, you gave me all that. I missed it at the bottom. Sorry. All right. We'll put that one in. You can pull out the sticker. That way I don't have to do it the next hearing. All right, what would you like to say with respect to bond, Ms. Perini?
We are asking for a lower cash bond. As I said, Mr. Thomas is not working right now, so any cash bond is a significant barrier to him to getting out of custody. He does have another case, I believe, in 1483 that does have $100 bond that may keep him in custody if he's unable to pay that one. But again, I'm just asking for a lower cash bond so he does have the chance to get out and return to his life and see if he can get these cases back on track.
You know, one of the problems I have here is that he is apparently unable to understand when he sets court dates and doesn't understand when the court reminds him that he said it and fails to show up. So that's very concerning since he has no ability to understand that he needs to show for court dates. I'm going to set a 2,500 10% bond. I'll lower it just by a little bit. And I'll schedule him for a court date on January 9th, 2023 at 9 a.m. So in the meantime, you should probably think about when you set court dates, those are the dates you have to show up for. Do you understand that?
yes, ma'am.
We'll talk about that on January 9th. Maybe you'll have a clearer memory at that time. Okay?
Like I said, I'm just a little lost because, like I said, I texted my lawyer and I never got a response or anything back.
You texted your lawyer for what?
I want like to see the discovery of any of these things. Like I never was in contact. Like I didn't know who was my lawyer, who my lawyer is, or my public defender. I'm sorry, man, my public defender.
They're the same, a lawyer and a public defender. But that doesn't excuse you from not coming to court.
Absolutely, and I told him, like I said, I think like we had caught COVID at my house, and I texted him that. Like you can even go back and check the records. I texted that guy that, and that was before my court date.
Are you telling me you had COVID on that date? And that's why
I texted him before that date.
All right, as I was talking before you interrupted me.
Oh, I'm sorry. I thought you were giving me a chance. I'm sorry.
Are you saying you texted him to tell him that you had COVID and that's why you did not show up in court?
Yes, could he get me another court date? And he never responded or anything.
Ms. Perini, please check on that with Mr. Banis and see if there's any proof of that. And then secondly, sir, this is on Zoom. So you just have to show up on Zoom. You don't even come into the courtroom. Well, maybe yours was different. Yeah, yours was set for an in-person because Nope. You were scheduled on Zoom. So it was just a Zoom hearing.
You know I haven't missed any court dates, ma'am. You know I haven't missed any court dates. You know I was at every court date.
You failed to show up twice.
Like the one on the 8th, I didn't even know about that one. But the one I thought it was the in-person one. I texted the lawyer. I said, "Hey, can you give me another court day?" Like
I will check with Mr. Banis to see, and double check all those dates and when he had COVID and all that stuff.
Okay.
yes, and
2,500, 10% is the bond, sir. And then we can see if we have any documentation of your failure to appear, and the reason behind that by the time we get back here on the 9th next week. Okay,
right.
thank you.
Thank you.
He's not getting out, but yeah, if he does get out, he needs to report to community corrections within 48 hours.
Thank you, Your Honor.